does all swear affirm the testimony that you give for this court to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Millings, if you would please introduce yourself to the court. Tell us your name, if you don't mind spelling it.
My name is Winston Rowell Milling, Winston Rowell-Milling.
All right, and you know Ross Harris?
Yes, I do.
Okay, and how do you know him?
We went to school together at the University of Alabama. We interned together at Home Depot, and more recently we have started a small business together.
Okay, much like Alex, y'all knew each other from college, work, and a separate business.
Yes.
Okay. Do you work in the same building that Ross works in?
I do not.
Okay. You work in the same building with Alex, right?
Yes, I do.
During the day on June the 18th, did the three of you and another friend have an open chat with one another?
Yes, we did.
Okay. And were you discussing matters regarding going to lunch and other matters?
Yes, going to lunch, seeing a movie after work, and general banter about things we find across the internet, random things.
Okay. Do you recall that Ross actually sent you a link to something that he found on Reddit or somewhere?
I recall a link. I didn't click on it, though.
Okay. Do you recall if it had anything to do with punctuation?
Something about something fails, but I don't remember what it was particularly about.
Okay. Was there anything remarkable about the kind of communications y'all were having on that day through that chat?
No, there's nothing different than normal.
You went to lunch?
Yes.
And Alex drove?
Yes.
Okay. You went to Publix?
Yes.
You would have been with Ross for what, about an hour?
Generally about an hour, give
Okay.
or take about 15 minutes normally.
During that time, you had a chance to observe him, see him, talk to him, hang out with him. Did you notice anything remarkable, unusual, different than any other day?
Nothing stood out on that day, no.
Okay. Well, was he acting all squirrely or like you had some anxiety that he doesn't normally have? Was there anything different about him?
Nothing that I can recall.
Okay. Well, was he joking and cutting up as usual?
Normally, yes. Talking about the movie for that night, we talked a lot about worst movies on Netflix that turn out to be good. Just random normal things.
Okay. And then then after y'all left Publix for lunch, you had a little extra time.
Yes.
Okay. And Ross asked to go to Home Depot to get some light bulbs.
Yes.
Right. Y'all all went into Home Depot, got the light bulbs.
Correct.
Right. You got back in Alex's car and drove back over to the treehouse.
Yes.
Okay. And Ross asked to be dropped off at his car. Do you remember that?
I don't particularly recall it. I was on my phone during that time. Lunches are mostly a getaway for us. I don't particularly remember a lot of things that happen. It's just a normal escape from work.
Okay. So
I don't remember him asking, but I do remember us not dropping him off at the front door.
Okay. So you don't have any present recollection of where you parked in relation to his car or him getting out or saying anything or anything like that at all?
I remember him getting out. I remember it wasn't at the front door. Where in the parking lot, I couldn't tell you. I was more just paying attention to my phone, surfing across.
Okay.
I don't remember what I was looking at the time.
All right. So you certainly then don't have any recollection of him trying to prevent or preclude the two of you from approaching his car, looking in his car, getting out, anything of that nature?
That would be abnormal. We normally just stop, he jumps out, and we drive on.
That's pretty much what happened that day, right?
As far as I can remember, yes.
Okay. Then when you got back to the office, the online chat continued between y'all regarding the movie later that night.
Yes.
Okay. Did you notice anything remarkable or unusual about the banter that afternoon?
No, I didn't.
Okay. In fact, did Ross continue to participate in a conversation with y'all online about meeting up at a movie in a couple of hours?
Yes.
You ever had a chance to observe Ross around his son?
I have.
In what context?
We've gone to the Marietta Festival together, my wife and myself, Ross's son and his wife. We've gone hiking on Kennesaw Mountain, the IT, picnic festivals, normal family events.
All right. What kind of dad was Ross?
He loved showing Cooper off to everybody. I mean, anything but loving. I couldn't think of anything else. He liked picking him up and bringing him around, showing him around. He was always happy. Cooper was always smiling.
Do you remember anything about Ross entertaining the children at the daycare?
No, I had no experience with Ross actually at the daycare.
Okay. You think Ross is capable of intentionally harming his son?
Objection. Speculation.
Sustained.
Thank you.
Has the interaction that you have personally observed between Ross and Cooper, has it been of a loving father-son relationship?
As far as I can tell, yes.
Okay. And that's from your personal experience in observing him and the family together, right?
Yes.
Are you aware if Ross has any hearing issues?
He is deaf in one ear, or mostly deaf.
Okay. Mostly being 99%?
I always have to go to the other side of his head to talk to him.
Okay. And you've been around Leanna as well.
Yes, I have.
And have you observed her to be a loving and devoted mother as well?
In the limited experience, yes.
Okay. More experience seeing Ross.
Correct.
Okay. I think that's all I need, Judge.
No questions, Judge.
You may step down.
I think that's all the evidence that we're going to this time.
All right. You wish to make any argument, Mr. Kilgore?
I do, Judge. Judge, this warrant alleges cruelty in the second degree as the underlying felony for a charge of felony murder. 16570 says cruelty in the second is when such a person with criminal negligence causes a child under the age of 18 cruel or excessive physical or mental pain. So we got to look at what's criminal negligence. OCGA 16-2-1 says that's an act or failure to act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured thereby. What does willful mean? Well, Black says willful means voluntary and intentional. We've heard a lot of suggestions and speculations and maybe even coincidences, but you certainly haven't heard any evidence that this was intentional. Certainly not what was charged in the warrant as well. What is wantonness? Black says that's conduct indicating that the actor is aware of the risks but indifferent to the results. I think if you take a look at the facts, specifically, Judge, the facts of the going to the car in the middle of the day, I think it's clear that, and the continued banter throughout the day with his friends, there's no evidence Ross was aware that child was in the car. Why in the world, if that were the case, why in the world would he bring his colleagues right up to the car? It makes no sense at all. So I don't think there's any evidence of wantonness. Reckless disregard. Well, Black says that's a conscious indifference to the consequences of an act. He's got to be aware that the child is even in the car for there to be a conscious indifference. I want to just go over a couple of cases quickly with the court. A recent Georgia Supreme Court case explained that criminal negligence necessarily implies not only knowledge of probable consequences, which may result from the use of a given instrumentality, but also willful or wanton disregard for the probable effects of such instrumentality upon others likely to be affected thereby. That's Sullivan versus Kemp, 293 Georgia at 770. If there's no evidence that he had knowledge that Cooper was actually in the car when he walked away and went to work, there's no evidence that he had that knowledge, it's not criminal negligence. It's a horrible tragedy and an accident. The Bohannon Case, which is 230 Georgia Appeals 829, the defendant in that case was convicted of involuntary manslaughter because she had knowingly picked her baby up from a babysitter, knowing that she was drunk and her husband was drunk, and then knowingly placed the baby in the bed between them. It was all done knowingly. Dad rolled over and smothered the baby. In that case, the underlying act wasn't a felony like here, cruelty in the second. It was a misdemeanor. It was reckless conduct. But the court explained that it was criminal negligence. Why? Because it was knowing. She knowingly undertook those acts. She knowingly put the baby in that situation. The act of putting your child in a car seat, that's what we're dealing with. That act is not inherently dangerous. Now, knowingly leaving your child in a car seat while you go about other activities, of course, that might be. But there's no evidence that Ross had that knowledge. Suggestion, innuendo, and all this about, well, we got motive because he's doing all this fantasy texting. Great. Well, first of all, it's not illegal. But second of all, that there's no connection, there's no nexus between that activity or those activities or that lifestyle even, and the suggestion that somehow this was intentional or had knowledge. There's no evidence of knowledge. So it's what I'm saying is this, Judge. It's not even criminal negligence enough to support a misdemeanor. Just a couple of cases I want to mention to the court that specifically involve criminal negligence involving a child. And in each of these cases, it explains very clearly there's got to be some knowledge or appreciation of the potential harm. Johnson versus the State, 292 Georgia at 856. That was a felony murder based on cruelty in the second. The court did find criminal negligence where the defendant left her methadone out for her child to get into, and then when the child went comatose, she just didn't seek medical care for a couple of hours. That was criminal negligence because her actions were done with knowledge. Morast versus the State, 748 Southeastern 2nd, 287. That was a cruelty in the second, and that was affirmed where the mother, she continued to take her child to a caregiver with the knowledge that the child was being basically injured and attacked by dogs. Nelson versus the State, 731 Southeastern 2nd, 770. That case, of course, was here in Cobb, and that was the one where the mother was charged. I believe it was involuntary manslaughter. And the court agreed there was criminal negligence in that case because she had knowledge or an awareness that taking her child and crossing a busy street in the middle of the night versus going down to the corner and crossing the crosswalk, she had knowledge that that was inherently dangerous. And unlike those cases, I would suggest to the court we don't have any evidence that he had that actual knowledge, that he knew the child was there when he went about his work that day. the warrant that we're looking at here. And this warrant's from the 24th. It's somehow trying to suggest that there was this knowledge because it says during lunch, said accused did access the same vehicle through the driver's side door to place an object into the vehicle. Said accused then closed the door and left. Well, Judge, the evidence that you've actually heard regarding that incident shows absolutely that he didn't know Cooper was in the car. He goes to lunch with two friends. You've heard from both of them. They said he's behaving completely normal. There was nothing squirrely about the way he was acting at all. Completely normal. Wasn't overly anxious. After lunch, they go get some light bulbs. He has his friends take him directly to the car. You heard, apparently in this video, he opens the door, tosses the light bulbs in. He doesn't linger. He doesn't get anything out of the glove box. He doesn't look back there. He doesn't do anything, nothing whatsoever to suggest that somehow he knows the child's in the car. Nothing. Thank goodness we got that video, because it's going to demonstrate just that. He's got no idea that Cooper's in the car. Why would he take his closest friends to his crime scene? Why would he do that, knowing that they're going to be witnesses against him at a later time? It doesn't make any sense at all. It makes sense if you realize he didn't know, and there's no evidence that he knew the child was in the car. I do want to touch on this, all this testimony you've heard about this fantasy texting or sexting or whatever you call it. There's no. Well, first of all, that doesn't evidence willful, wanton, or reckless disregard. The state's thrown that out there with no nexus whatsoever between what he does in his private time and accidentally leaving his child in the car. No nexus whatsoever. None. Okay? So he does this fantasy texting. It certainly is not evidence that he consciously left his child in the car. There's nothing per se nefarious about it in this context. Perhaps it's immoral. But certainly there's no relationship or connection that's been made to his child being in the car. Just a suggestion that, he's got all this other stuff going on. We didn't hear exactly what time it occurred, but I suggest to the court this: if there was any evidence that this was going on that phone during the time that he was driving his child to Chick-fil-A, driving his child from Chick-fil-A, we'd have heard about that, but there wasn't. I think the real purpose of all that is to publicly shame him. It's not like his family hadn't been through enough already. (1622) says that an accident is where it satisfactorily appears that there was no criminal scheme or undertaking, intention, or criminal negligence. I want to read the court what our pattern jury instruction says on accident. An accident is an event that takes place without one's foresight or expectation, which takes place or begins to exist without design. The state wants to suggest all of these little sound bites all thrown together somehow constitutes some grand design. I think it's very telling, Judge, that this motive we're hearing about, it's financial. They got financial problems. There's a life insurance policy. They specifically ask about that. There's a life insurance policy. But yet, when I press the detective on that, no, really, there wasn't any evidence. There wasn't anything that he determined from his investigation whatsoever, specifically, that they were in any sort of financial distress. Nothing. He said, well, we thought Ross had put some money on a credit card, or Ross admitted that he put some money on a credit card. Well, their bank statements apparently weren't overdrawn, or at least he didn't know about it, if they were. No evidence. There's got to be some knowledge and foresight, Judge. Foresight or expectation. There's got to be some design. If not, it's an accident. I suggest to the court that we haven't heard that. What happened here was that Ross pulled out Chick-fil-A and his mind went elsewhere. What happened? Now, you got to pull into traffic. You got to go through a light. It's easy to get distracted when you get behind the wheel. Everybody's done it. His mind's already skipping ahead to the rest of the day. And judges, as much as we want to think that there's no way that we could ever forget a child. I mean, of all things, we can't forget a child. We do. People do. I don't know that the governor would be instituting a campaign for Look Again if it never happened. We forget things in a moment. That's how we forget things. I can't think of how many times, Judge, that I've had my leftovers boxed up in a restaurant and they're sitting right at the table, right in front of me. And I get up and I walk out and I go to the car and I drive home and then because we forget it an instant, because our mind races ahead. And when he pulls up to that light and he's got to get out of that traffic, it was done. It was over. He had already forgotten. The results of that forgetting, in this case, Judge, were absolutely catastrophic. The results were as bad as you can have for forgetting something. They were absolutely catastrophic. But an accident doesn't become a crime because the results were catastrophic. And that's what all this is about. The results were terrible, awful. And that man's going to have to live with those for the rest of his life, as is his wife, as is his family, as is the community. But that don't make it a crime. I'm going to ask the court to let us reset here. And by that I mean, Judge, they don't have the evidence. They haven't presented the evidence to you at this juncture, certainly, that there's criminal intent or criminal negligence. So I'm going to ask you to dismiss this warrant. Dismiss it. And in the cool of reflection, after we get rid of all of this, all the cameras, all of this, the district attorney, in the cool of that reflection, if they think at that juncture they've got the evidence of criminal negligence or intent or whatever they think they've got, and they can make those connections, and that nexus, they can take it to the grand jury. But I'm asking you to give us a reset here, to clear all these people out of our community, and let's deal with it in the cool of reflection, not under all these lights, Judge. And the way to do that is, I'm asking you to dismiss this warrant, not just because it's the right thing to do, because they don't have and haven't presented to this court the evidence for this case to go any further at this point.
All right. Thank you, Mr. Kilgore. Mr. Bourne?
Thank you, Your Honor. It was a good bit of theater here. It was interesting. He talked about leftovers. You leave leftovers in the car, you get out of your car, you go in your house, 30 minutes later you remember, I left some spaghetti in the car, or I left this or that. This was a child. Not a child left out for 30 minutes, not a child left out for an hour, a child left out in the car for over 7 hours. Judge, it is almost, and I'm not going to beat a dead horse, which I did earlier, the evidence is overwhelming. We submit of malice, but especially of criminal negligence. I'll cite one case to Your Honor, Court of Appeals case, Kane versus the State, July 31st, 2007 decision, applied felony murder, or criminal negligence. The defendant in that case was convicted. She let her kids, did not supervise them correctly, knew they were in her house, didn't supervise them correctly, didn't keep tabs on them. The children went out and drowned. They went out and drowned because of her inattention. And remarkably, in that case, part of that was due to, and it was admissible, that she actually had sex partners that night over and stayed up late and didn't pay particular attention to the kids because she didn't get any sleep. At a minimum here, Judge, to say that that is not relevant to his negligence, the fact that while that baby was out there cooking in that car, he was showing pictures of his private parts to other people, was totally talking to everybody else in the world about everything else other than his child, gets an email in the middle of the day about his daycare, goes out to that car and tosses light bulbs in there. Who tosses light bulbs? I think it is remarkable and speaks volumes that he didn't stick his head in that car. He knew what he was going to find. He knew exactly what he was going to find. Judge, I think most importantly, one of the things you have is your common sense and reason, and you have those photographs. You heard the detective. You see where that car seat is. 30 seconds after he had kissed his son goodbye for the last time, he's at that decision where he decides to go to work. That's where he makes that decision. After making the U-turn where he turns right, which is the same thing he said he did when he notices the child later that day. And he decides to go on through and go to work. He decides to go back out to that car, and he decides to wait until the car's passed. And you heard from the detective about the video that the car had passed, and then he opens the door. He stops when a person starts walking toward his car and waits until that person passes, and then re-enters. That morning, he waits 30 seconds in that car after parking, after having had to turn around and back up. 30 seconds with that child right beside him. Judge, the warrant is for criminal negligence and felony murder based on cruelty in the second degree. We believe the evidence has shown much more than that. We believe the evidence has shown that this was intentional. However, at this point, we're asking you to bind it over on the warrant that you have and hold this defendant on this warrant, felony murder based on cruelty to children in the second degree. I just don't even believe it's a close decision, Judge. Thank you.
All right, thank you. Well, probable cause is a relatively low threshold, and the court is persuaded that at the very minimum there's reckless disregard for the safety of others in the conduct of Mr. Harris, and that the moments or seconds that elapsed between the time he placed the child in the car seat until he got to his workplace, which is a matter of moments, he allegedly forgot the child. And then for him to enter the car later that day after 4 o'clock in the afternoon when the child had been dead and rigor mortis had set in, and the testimony is the stench in the car was overwhelming at that point in time, that he, in spite of that, got in the car and drove it for some distance before he took any action to check on the welfare of his child. So I find there's probable cause for the 2 charges contained in the warrant. Anything else today, Mr. Kilgore?
Judge, I would like you to consider bond. I've got several witnesses and wasn't fortunate to find just first discussion.
Well, you have a right to present what evidence. You wish to state in your place what they would say, or you have 1 or 2 witnesses you want the court to hear from?
Okay, Judge, I'll call his brother Michael Pagans at this time.
All right.
Here's your right hand, sir. You do so solemnly swear or affirm the testimony about to present today before this court will be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Sir, if you would please tell the court who you are, if you could give us your name and spell it.
Randy Michael Bagents Jr., Baygents.
Okay. And how are you related to Ross?
I am, my brother.
Can you tell the court why you don't have the same last name?
My mother remarried when I was 1 year old and married Ross's dad.
Okay. And were you in fact raised with Ross?
I was.
Okay. We have heard something today about him having employment in law enforcement, but let me ask you first what it is that you do for a living.
I work for the city of Tuscaloosa as a police sergeant.
Okay. And what is your job there?
I'm the basic training coordinator for one of the regional law enforcement academies for the state of Alabama.
Okay. And has Ross, in fact, ever had any sort of employment in law enforcement?
He has.
And what was that?
He worked as a police dispatcher for the city of Tuscaloosa.
Okay. How long did he do that job?
I think a couple of years, 2 or 3 years, maybe. I don't remember the exact time frame.
Okay. And tell us, Ross graduated from college?
He did.
University of Alabama?
He did.
And he works at Home Depot?
He does.
Can you tell us how long he has lived in this community?
Oh, several years since he graduated from the university. 3 years, maybe 3, 4.
Okay. And of course, he lives with his wife.
Yes.
And do they have a house or an apartment?
It's an apartment.
All right. And that's here in Cobb County?
It is.
And his wife has a job in Cobb County as well?
She does.
Can you tell us, have you had an opportunity, or did you have an opportunity to observe your brother and his son together?
Yes.
Can you tell us about that?
He was a loving father. He loved his son very much. We went on family vacations together, and he was a good dad.
Michael, do you believe that if the judge were to allow us to have a bond in this case, do you believe that your brother would be out committing crimes?
No.
Okay. If the judge were to allow us to have a bond in this case, do you believe is there any reason to believe that your brother would not come to court as directed?
No.
Okay. Thank you.
How you doing, sir?
I'm good.
Sorry you have to be here today. How long have you been in law enforcement?
Almost 20 years.
Okay. I think one thing we've all learned being in law enforcement, that people we know, sometimes we don't really know what's going on in their lives. Would you agree with that?
Sometimes, yes.
Okay. Do you know where he's going to be staying if he gets out on bond? Is he coming to live with you?
I'd imagine he'd stay at his house.
Okay, so he would stay in Cobb County
I would think so.
with his wife.
I would think so.
And you or your family wouldn't be there to kind of watch him and make sure he shows up for court or anything like that, right? I mean, he's an adult.
He is an adult, but I'm sure we would be visiting him quite frequently.
Okay. Now, you stated that you told the judge you didn't think he would commit crimes while out on bond, correct?
I don't think he would at all.
Okay. Were you aware that he's actually committed acts that would be crimes in the state of Georgia in the past year?
I was not.
Did you know that he's been chatting with underage girls and getting pictures of their breasts sent to him?
I did not.
Would that change your opinion as to whether he would be likely to commit crimes if released on bond?
No, it does not change my opinion.
That's all I have, Judge.
Who would help him post a bond if bond was set?
His wife.
Does she have resources that you know of?
I think so.
All right. You may step down.
Judge, may I just ask one other question?
You may.
Is it fair to say that your sister-in-law and your family are not people of great wealth?
I think so, yes.
Thank you.
You may step down. Any other witnesses, Mr. Gilroy?
Melissa Sellers.
Judge, Ms. Harris had a medical issue. This is Ms. Penny Harrison.
Okay.
Okay.
Raise your right hand for me, please. You do so solemnly swear or affirm the testimony you're about to present today before this court to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Harrison, if you could just please tell the judge who you are. Spell your name.
Okay. I'm Penny Harrison, PennyHarrison.
Okay. And Ms. Harrison, what do you do?
I'm the children's pastor at Stonebridge Church.
Okay. And Stonebridge Church, the one that's on the corner right here on the square, just like across the street from this building?
Yes, it is.
Okay. How do you know Ross?
I know Ross and Leanna as members of our church.
How long have you known them?
Approximately 2 years.
Okay. And so the court will understand what is sort of the context in which you would be interacting with the Harrises.
Okay. Well, I met them when they started coming to our church in the summer of 2012. There was a fall of 2012, there was a small group that I was a part of as a staff member, and they were in that group. And then I also know them as parents of Cooper in our ministry.
Okay. And did you ever see Ross and Cooper have an opportunity to see them interact with each other?
I did.
What kind of parent did you know Ross to be?
I knew him to be a typical loving father of a toddler.
Are Ross and his wife involved in church activities?
Yes, they're in a small group, and Ross serves in our worship band. And Leanna has also served as a volunteer in our nursery.
As one of the pastors at that church, is it your belief that that Ross has some support there at the church, that being people that he can lean on that might help him?
Yes, I do believe that.
You believe that if the judge were to grant a bond, that Ross, it would be a risk to commit crimes?
No, I do not.
Okay. If the judge were inclined to give a bond in this case, do you have an opinion whether or not Ross would actually show up to court when he's supposed to show up to court?
I think he would.
And that's based on your personal interaction with him over the last couple of years?
Yes, sir.
Okay. All right, Judge, I think that's all I've got.
Good afternoon, ma'am.
Hi.
So you know Mr. Harris through church, is that correct?
Yes, sir.
Do you know him, like what goes on in his home life or anything like that?
No, sir.
Okay. And were you aware that he was actually at times while on the computer chatting with other women about his church going and playing guitar, that he was in the same frame, sending pictures of his anatomy to them and having sexually explicit conduct with them?
No, I did not.
Talking about cheating on his wife?
No, I did not.
If he were doing that, would you agree that maybe you don't know everything about Mr. Harris?
I know him in a church setting, and that's all.
Okay, that's all. Thank you, ma'am.
Can you step down?
Thank you.
Anything else, Mr. Kilgore?
No more evidence for purposes of bond, Judge.
All right. What are you asking for, Mr. Kilgore?
They're people of limited means, Judge. I'm asking for a $50,000 bond.
Mr. Boring?
Judge, we are objecting to bond given all the circumstances that he has been committing crimes even before this. That I believe it speaks volumes when he said in those chats, he was asked, do you even have, does your conscience ever kick in? And he said, no. It's obvious this man is leading two different lives, and I don't think he can be trusted at all times.
Well, based on the number one murder charge, obviously, and facing a minimum of life sentence with a minimum mandatory of 30 years in prison, and conceivably in the future a possible death penalty case, the court will deny bond today.